Hello, everyone, and welcome to the Columbus Metropolitan Club. I'm Carol Newcomb-Aludo, Chair of the CMC Board of Trustees. I'm happy to see everyone here today on such a beautiful, sunny but cold day. Please be aware that CMC's traditional audience questions will be submitted in writing today. You will find a piece of paper in your forum flyer for your questions. Please make sure to include your name. About halfway through our program, volunteer members of CMC's program committee will collect these, sort them for appropriate and balanced content, and select the questions to be read aloud. CMC is sponsored today by the Ohio Farm Bureau Federation and Hannah News Service, each represented here by many friends and associates. Please help me thank them. Today, we explore State Issue Number 1, Drug and Criminal Justice Policies Initiative. Recent polls reflect that much is unknown about Issue 1 as we head into the final weeks before the election. As in all things, once knowledge, details, and nuances of the fact inform us, our decisions and our conscience are far better off. To that end, we look forward to learning more from expertise and passion of our speakers today. Please welcome, speaking on behalf of Issue 1, Deputy Director for Policy at the Ohio Justice and Policy Center, Stephen Johnson Grove. And Ohio State Senator from the 9th District, Cecil Thomas. And speaking against Issue 1, Franklin County Common Pleas Judge Stephen McIntosh, and Chief Justice of the Ohio Supreme Court, Maureen O'Connor. Now, please welcome our host journalist, Ohio Public Radio and Television State House News Bureau, Joe Engels.
Thank you, everyone. Welcome. We'll start off today with opening remarks, 2 minutes from each side. The anti-side, I believe, won the coin toss. We'll go first. Or the for side won the coin toss. The anti-side will go first, followed by, am I right? Followed by the for side. So each will have 2 minutes, and so Stephen and Senator Thomas,
We're
2
second.
minutes.
We're second. We're second.
You're second, okay.
That's right.
So we're going this side first, okay. So the anti-side will go first. Here we go. Justice O'Connor and Judge McIntosh. Sorry about this.
Thank you. Thank you very much. Thank you, ladies and gentlemen, for taking the time this afternoon. Thank you to the Metropolitan Club for sponsoring this debate. This is probably one of the most important decisions that you will make on Election Day or earlier if you're an early voter. Issue 1 involves the safety of our state, of our communities. Both the proponents and the opponents of Issue 1 agree that treatment for drug addiction is preferable to incarceration of low-level felony drug possession. The positions diverge when the proponents support downgrading felony drug possession to a misdemeanor, and by a constitutional amendment, forbid judges to incarcerate addicts under any circumstances. The opponents support and, in fact, do offer treatment instead of incarceration for low-level felony drug possessors. Evidence-based research supports drug courts as the gold standard for the response to drug addiction. An essential component of the drug court and all probation sanctions is accountability by the defendant. Part of accountability is a meaningful consequence for behavior that deviates from the conditions of probation or the program set out in drug courts. Deviation includes failure to comply with probation requirements, failure to participate in treatment, failure to address conditions imposed by the court to which the defendant had agreed. An evidence-based graduated sanction regimen is mandatory. One of the sanctions must be the possibility of incarceration. Without that, the process is a toothless tiger. Addicts cannot recover on their own. I think that both sides agree on that. When the proponents say that downgrading felonies to misdemeanors has been done successfully in 12 other states, they fail to acknowledge that measures were not placed in the state's constitution. They were by statute. The danger of the measure in the Constitution is that its provisions cannot be canceled when they don't work. Constitutional amendments are written in stone compared to statutes. We need flexibility to respond, to keep what works, and to jettison what does not.
Justice O'Connor, I'll have to stop you there because we are out of time, but I would like the other side to go ahead and make your opening statement.
Sure. Thank you. Thank you, Chief Justice, and thank you for all you for coming today to listen to this very important conversation about Issue 1. Issue 1 is about increasing the health and safety of our communities through less incarceration. We have a 50-year track record in this country and in this state of the failed war on drugs and the trends of mass incarceration. We have 50,000 people in our state prison, and there are many there for low-level drug possession. We are wasting money putting them in those prison cells, and we are wasting human lives. We can do better. The opioid crisis that we're facing right now, I was at the dispatch and the thing that hurt me the most was seeing the 2 years ago headline of 3,050 people in state who had died of opioid addiction overdoses, and now knowing that it's 4,800, 14 people dying per day. We can do better. We need to make a significant shift. Issue 1 is that shift. For the rest of my time, though, I really want my friend and my own state senator and neighbor, Cecil Thomas, to take some time.
Thank you. I just want to follow up with the current policies we have in place isn't working. We continue to see an escalation in deaths, escalations in our prison population. In other words, it's not working. So we have to think outside of the box. Issue 1 is a methodology by which we will be thinking outside of the box. Is it perfect? By all means, no. But yet and still, it gives us an alternative that has not been tried. Other states have been very successful. The only argument from our Chief Justice and others is that, well, it's not in their Constitution. The fact of the matter is with the political will of our legislature and the community, the people, if there are any imperfections that may cause some concerns, we can change that. It's just that simple. The fact of the matter, though, is that I see a red sign that means stop.
There we go. There we go.
Thank you. I apologize.
I'm going to throw the first question your way, and it's kind of related to where you were going, so you might be able to finish that thought. This is a proposed constitutional amendment. If it passes, it would be hard to change it. Tell us why you decided to go with a constitutional amendment.
Yeah. Either way.
Okay. I'll say the states that have done this to reduce felony drug possession down to misdemeanor, those that have done it by citizen-initiated statutes have protected statutes. So in other words, the legislature could not repeal it but for a supermajority or after a certain period of time. We don't have that in Ohio. What we have is a legislature which has more than a decade track record of not doing productive reform, and we would do the same amount of work, the same number of signatures gathered, all the big heavy lifting to try to get this thing on the ballot initiative, and literally November 7th, that state house would repeal it. That's what we've seen, and that's why we can't entrust this magnitude of a reform to that legislature. The citizens of Ohio need to take this on for themselves. And I think what Senator Thomas was alluding to is what's sometimes glossed over, the space that's possible in this constitutional amendment for implementation legislation.
Yeah, 18 states have decriminalized it. But one of the things I want to stress on is that as a legislator, there's not been a serious political will to take the bull by the horns, if you will, and make some drastic changes. I sat on the recodification committee for 2 years with representatives from all aspects of the criminal justice system. We left our D and our R at the door, and we put our heads together, and we came up with serious legislation. However, that recommendation report is sitting on somebody's desk collecting dust.
Okay, Justice O'Connor and Judge McIntosh, I have a question for you related to this. You say the drug courts and the system we have in place now is sort of working, and there are some benefits to it. We're seeing 14 people, as Mr. Johnson Grove said, 14 people dying every day from opioid abuse. So what evidence do you have that there is something that is actually working now as opposed to this amendment?
Good afternoon, everyone, and once again, thank you for coming. I am the drug court judge here in Franklin County, and for those of you that are not familiar with what a drug court is and what one looks like, for persons that agree to get into my drug court, and let me make that clear, they have to volunteer to get into my drug court. I cannot mandate them to do so. But what it means for an individual that actually gets into my drug court is that for the first phase, I get to see them every single week. I meet with the with the various providers of services for them in advance. I find out how well they're doing, how poorly they're doing. If they're doing well, we continue to encourage them to do so. If they're not doing well, we look at alternatives treatment for them. As they progress through the program, individuals that successfully complete the drug program here in Franklin County will take them approximately 18 months. Okay, that's a huge commitment from someone that's trying to get off of drugs. I mean, we obviously, the sort of structure that we provide is lessened as they continue to progress through. The statistics show that drug courts do work because of the fact that we can provide the type of structure, because of the fact that we can meet with the individuals weekly, at least early on, and be able to give them some guidance. I mean, as most of you may or may not know, the difficulty with individuals suffering from addiction is that many of them don't have a support network in place. They don't have individuals in their communities, or sometimes even in their homes, that will provide them the support that they need to get through and over their addictions. That is just what I'm doing in my drug court. Of the other 16 judges that we have in the Franklin County Court of Common Pleas, through our probation department, we're constantly referring individuals into drug treatment. But again, we cannot make someone do drug treatment. However, what we've been able to see is if we get people into treatment, even though many are reluctant to do so, those that tend to do what we or the probation department ask, many of them all of a sudden find themselves in recovery, and they're actually getting the treatment that they were fighting against. My concern here with issue 1 is that because of the fact that it's misdemeanor offenses and a judge can impose sanction on the first 2 sentences, the hammer, so to speak, or the ability to get persons to, 1, get into recovery, and then enforce that recovery is lessened.
I'd like to address the criticism that Ohio has been inactive in the fight to deal with drugs. We've just heard it 50 years. I've heard it 10, 40, 50 years, depending on what version they're spinning. But nothing could be further from the truth, and I want to start with Medicaid expansion. Ohio spends $1 billion a year on Medicaid expansion, and we could not offer the treatment to the folks that are suffering from substance abuse disorder if we didn't have Medicaid expansion. We're also equipping all of our first responders with Narcan. The number of lives that have been saved with Narcan, number in the tens of thousands. Drug courts, you've just heard a testimonial as to the effectiveness with proliferation of our specialty dockets, almost 250 in the state of Ohio. Over 170 of those are drug courts. The rate of success in drug courts is 70% or over. All judges who sentence low-level abusers will tell you, as well as the state's treatment providers, that most addicts will not voluntarily go to treatment unless sanctions are part of the consequence. They won't stay in treatment. The odds are overwhelming that they will not complete the program without a tough-love judge such as Judge McIntosh. Ohio is the recipient of over $112 million just recently in federal dollars to be used to expand our treatment capacities. The money will go directly to local communities for treatment of addicted people. The Bureau of Worker Comp, you may have read just this week, $5 million will be given to employers so that they will be able to employ individuals who are going through treatment, who are in the recovery program. And we all know that employment is an essential component of recovery for obvious reasons. VAWA, Violence Against Women. Ohio is the recipient just recently of over $12 million to address victims, female victims of violence. Our educators are mandated to include instruction in prescription opioid abuse prevention in the the school district's health curriculum. In reality, Ohio is proactive in both diverting defendants from the prison system and returning dollars to the local courts to deal with these defendants by the program called TCAP. I'm sure you're all familiar with that. HB 86 it requires a judge to sentence felony 4th and 5th degree defendants to 1-year-long community control sanction. They are mandated community control, not prison. Physicians are limited in their ability to overprescribe opiates. All distribution of opiates must be reported through the Prescription Drug Monitoring Program, and doctor shopping has declined to levels that have not been seen before the opioid crisis. Our Regional Judicial Opioid Initiative, an information and best practice and policy sharing think tank, involves 8 states. It's been recognized nationally as a model judicial/state response initiative. Heroin deaths have declined by 46%.
Okay, let me stop you right there, and we're going to kind of shift this to a little bit different area. The passage of this issue would allow some people who are currently incarcerated to be resentenced. How would this affect courts and communities in the long and short term? Stephen and Senator Thomas, I'll let you answer that.
That would be sort of an initial phase. I don't know how long exactly it would last, but there'd be a period by which people could petition to have if they're in for felony level drug possession, the amendment operates to allow them to petition to also take advantage of what Issue 1 creates, which is a reclassification. So if they're in for one of these 4th or 5th degree drug possession cases, could get it reclassified to a misdemeanor and theoretically be released from prison. This also benefits the untold thousands, and I'm trying to do that number crunching, but many thousands of people in the state who have a felony drug possession case from any time in their past. They also could petition a court to have that reclassified. Presumably, people would take advantage of that near the beginning of the Issue 1 sort of era, and that would taper down.
And let me add to that, the felony conviction has been a huge barrier to families that have a father, child or father ends up arrested on one of these low-level nonviolent offenses, and they're sent to the penitentiary. As an undercover officer in the Cincinnati Police Department back in the 70s, we used to arrest for drug addiction is nothing new. It's been going on way back. And I worked undercover narcotics, and we used to arrest for these low-level offenses. And a lot of times we had what was called detox centers. Back then, there were about 8,000 individuals in the penitentiary. 8,000. 200 and some of those were women. But then when we had the war on drugs, the culture was prior to the war on drugs, find ways to treat this as a health issue as opposed to a criminal issue. However, when we changed our direction and began to focus on the war on drugs, I was one of the officers making arrests. I would arrest an individual. He may have had a crack pipe. He may have smoked the crack, but the residue in the pipe was enough to charge him with a felony, and he ended up in the penitentiary. So our prison system has swelled since then from 8,000 back then to 50,000 where we are now. And a huge percentage of those are low-level nonviolent drug offenses as well as other nonviolent offenses, low-level. We have to think outside of the box, folks, because what we're doing now is not working.
And Judge McIntosh and also Justice O'Connor.
I'd like to respond to the numbers that were just mentioned as far as a huge population, or percentage of our population in prison. 49,500 people are in the institution. Should some people be released from the institution? Would it be preferable that they were under community control? Obviously, I think the answer is yes. But of the 4th and 5th degree individuals, and these are all 4th and 5th degree, not just drug abuse, 5,600 in our institution. So when they say that there's the vast majority, or there's a significant number, or whatever, this is about 10% of the population are 4th and 5th degree felons across the board. And that's not just drug possessors. That encompasses a lot of other 4th and 5th degree offenses that are in the institution. Significantly, many of those are not drug possession cases.
Okay, and if I could just make one comment as well. Again, a lot of what you hear is that if issue 1 passes, that it's going to be the sort of be-all for drug treatment. And again, I would ask everyone, please read the amendment. And the part that I just referenced previously, part of the amendment states that it will prohibit jail time as a sentence for obtaining, possessing, or using such drugs until an individual's 3rd offense within 24 months. What that means is that a person gets picked up for a low-level drug offense, they get charged as a misdemeanor, a judge imposes a sentence and says, I'm ordering you into treatment, the defendant says, I'm not going to treatment, and the judge cannot impose any sanction on that individual. They pick up a 2nd drug offense. The judge orders them into treatment. They say, I'm not going to treatment. Okay, and then the judge cannot impose a sanction. It's only after the 3rd time that they pick up a low-level drug offense within 3 years that the judge can then say, I'm ordering you into treatment, and if you don't go into treatment, I'm going to impose some sort of sanction against you. Okay, individuals are not going to go into drug treatment if there's not someone or some sanction, or they're aware that there's some sanction or consequence for their failure to do so. And the clear language of this constitutional amendment is that it's not until the 3rd offense that any judge could do anything to a person that's non-compliant.
Stephen, would you like to, or Senator Thomas, would you like to respond?
I just want to be clear, our argument isn't with drug courts. We really support drug courts. Issue 1 is going to create more funding for drug courts because we're going to divert low-level people out of the prison system and allow that money to be spent on evidence-based drug treatment and services and supports, a broad array of programs that are needed in the community before people get criminalized and perhaps in the drug court context. And the other thing to be crystal clear about is that issue 1 for probation violations does allow jail incarceration, which is the process by which a drug court judge would hold someone accountable. Issue 1 requires all sorts of accountability. And I think that's one of the core values of what the Issue 1 campaign is all about. We are absolutely about safety and accountability. People need to be held accountable, but accountability doesn't need to look like a prison cell. It doesn't need to look like our overcrowded jails. There are other ways to hold people accountable, more transformative ways. And yes, jail is possible, but let's wait to get there until we've tried every other option. That's why Issue 1 is an intelligent and carefully crafted reform.
Okay, Stephen, so following up on that, your opponents have said that passage of this issue would allow for people convicted of even more serious crimes like burglary, assault, maybe child molestation. It would allow them to be set free. Can you address that?
Well, set free. Everybody who's going to earn credit. So let's back up. Issue 1 allows for an expansion of Ohio's existing earned credit program. We have a program in the state where a certain class of people can take programs or do work and earn time off their sentence. There are 40 states in the country that have an earned credit program of some kind. We are the stingiest of those 40. We give the least number of credit to the least number of inmates. What issue 1 would do is expand that so that more people can earn time and they can earn it at a reasonable rate. It's basically you get for every 2 days of programming, you get 1 day off your sentence. So if you can imagine someone taking a program that's once a week, that's 4 weeks in a month, so that's 2 days off their sentence for 1 month of programming. Alabama gives 20 to 40 days off per month, in some cases 75 days off per month for programs. They give 30 days off just for donating blood. Alaska allows the cap to go up to as much as 33%. The Ohio cap under issue 1 would be 25%. Arkansas gives 30 days per month, as well as 90 days additional for completion of GED or other vocational programming. There are many other states that will be still vastly more generous than we are with earned credit, and I want to reassure you, the sky has not fallen there. There is no indication that public safety has gotten worse, that crime has gone up, that drug treatment has gotten, or drug abuse has gotten worse because of this expansion of earned credit. And I think the most powerful thing for me was when I was at Ohio State a couple weeks ago, and unbidden, that we were doing a debate just about the earned credit piece. And there was a woman who got up, a student, I presume, from the law school, who said, I'm a crime victim, and all I'm hearing you say is you want to keep these people in forever as long as possible. What I want to know for my safety is that when they get out, they're actually a different person. That's what makes me feel safe. So 15 years for someone sitting inside doing nothing versus 12 years, and they've actually turned their life around and have the shot of getting a job when they get out, that's more safe for me. So that's the kind of safety we're talking about when we're talking about expanding earned credit.
And Judge McIntosh and Justice O'Connor, what about that?
Well, first of all, I think that this is one of the misinformation pieces that is in this amendment. The fact of the matter is nobody's going to earn 25% off their sentence. By Mr. Johnson Grove's statements, he was on a program with Karen Kassler, and let me quote, "It will be very rare that someone will earn 25% reduction. Only the, quote, super gold star inmates, the best of the best, will earn this." Quite frankly, our institution, Department of Rehab and Corrections, does not have the capacity to do extensive programming, treatment, et cetera, in the institution so that all inmates, except for murder, rape, and child molestation, are going to be able to earn 25% off. People who have loved ones in the institution are encouraged to vote for issue 1 because they think their loved one is going to get out of the institution that much sooner. And the fact of the matter is, there is nothing that is going to make that happen, and that is extremely misleading, and I say it's cruel.
Sure.
Thank you. One comment, first of all, is that the drug courts, there's a waiting list a mile long of individuals who would like to get into drug court, but they can't. Now, on this whole issue of, the justice just said the prisons doesn't have the capacity to do the treatment. I attended 2 prisons. I went and toured 2 prisons in my last term, and in each one of those prisons I was walking through, and there was one area that was like a barracks, and I saw hundreds of individuals just lying in the beds at 12 o'clock in the afternoon, just sitting there. I said, well, what are they doing? Why aren't they into anything? And they said, well, we just don't have the capacity to get them into the programs. They had a number of different areas that they could participate in, but that was just, they were full. So my point is that a lot of those individuals, that 5,000 or whatever the number was mentioned, those individuals are those that don't need to be in there. And then they also indicated there are a number of individuals in there that have mental health issues other than drugs, and they don't need to be in there. And this is the echo coming from the director of the Department of Rehabilitation and Corrections. He said a huge percentage of those folks don't need to be in the penitentiary. Thank you.
Okay, so let me ask you, these people who are in prison, they're going to get out at some point. And when they get out, issue 1 would provide them a mechanism for trying to erase the stigma with their conviction, so that they're able to get drugs or able to get jobs and move on from their drug conviction. Can you explain that, Stephen and Senator Thomas? And then also, can you respond to it after they do that?
You got to this earlier, Senator Thomas, but my office, the Ohio Justice and Policy Center, has been around for 20 years, and one of our main programs is providing legal services to people with criminal records, mostly in the greater Cincinnati area. Serve thousands of people, and I've talked to hundreds and hundreds of them myself, who have felony records. Out of that, we build a database funded initially by the Ohio State Bar Foundation, the Civic Database, which catalogs every single law in the state that creates some kind of barrier based on a felony conviction. So because of that research, and you can look up the Civic Database, we know exactly that when someone has a felony drug possession, there are 580 state laws and regulations, this isn't even federal law, that bar them from something. Most of it's job related, some kind of license, some area of civic life they can't do, everything from adopting a child to having a mortician's license to anything in between you can imagine can be barred when you have a felony drug possession case. That's 580. When you convert that case to a misdemeanor drug possession, it goes down to 230. That's still a lot. But that's hundreds of jobs that are now suddenly open, the labor market that opens up for people with these decades-old drug possession cases who really never belonged with a felony on their record and now have one. They could get this reclassified to a misdemeanor. Jobs and housing are going to open up. That's a huge boon to the state, in addition to the many thousand that won't be in state prison.
Justice O'Connor and Judge McIntosh, what do you think?
Yes. Well, a couple of things first. When I got on the bench 12 years ago, one of the things that I indicated, or one of the things I indicated to folks out in the community was that since I'm going to be sending people to prison, that I wanted to visit the prisons to see what was going on. I've had an opportunity to visit 7 prisons in the 12 years that I've been on the bench. And one of the reasons that I wanted to visit the prisons was because we as judges have opportunities to release people from prison early through judicial release. I wanted to see the types of programs that were being offered. Because when someone requests early release from me, I get an institutional report. That institutional report lets me know whether this person has been compliant with the rules of the institution, as well as what programs and what classes that they've been involved with. And I tell them all the time, I said, if you want me, at the time of sentencing, if you want me to release you early, my expectation is that you're going to follow the rules and that you're going to get into some classes of programming. And when you file your motion for judicial release, if you're doing those sorts of things, then I'm going to give you another chance in the community. If you're not doing those sorts of things, what you're telling me is that you want to remain in prison. And so we as judges currently have a way to at least allow certain individuals to get early release after we've had an opportunity, having sentenced them, to see if they've taken advantage of the programming that's within the prisons.
Okay.
So, I mean, I don't disagree, one, that individuals being released from prison need resources for job training, if necessary, for drug treatment, as well as a whole host of other things to be reintegrated within the community. And a lot of those things are taking place now through a variety of reentry programs throughout the state.
Okay,
Could I just add one comment here? If you're talking about someone who 5-10 years ago had a drug possession charge, a low-level drug possession charge, and that's their only felony, they're eligible for expungement. They can have that record sealed as though it never happened. And so, am I in favor of maybe reducing the time between the completion of a sentence and the ability to have your record expunged? Yes, I think that would be a reasonable. That's a statute that can be passed. It can be discussed in the legislature, and that can occur rather quickly. So between what Judge McIntosh has said and then the concept of expungement of your record, there are programs, there is the ability for someone who is a one-time offender to have their record, their slate wiped clean.
Okay, we will move to the audience questions in just a few minutes, but first, there's a bipartisan plan that was developed by Democratic Columbus City Attorney Zach Klein and Republican Franklin County Prosecutor Ron O'Brien. It has the support of some of the people who oppose Issue 1. The plan would require the legislature to pass it. So let me ask Stephen and Senator Thomas, what are your thoughts on that plan?
Go right ahead.
Well, first of all, let me say this. When we had the issue of gerrymandering and trying to figure out how to get the lines redrawn, it wasn't until the realization that the number of signatures that were collected were allowed to go on the ballot. It was when the other side of the aisle decided to want to have a conversation about gerrymandering. I akin that to what we're talking about here now. The citizens had to take charge because the legislators have just not done the job. And by taking charge, the citizens collected the signatures, over 700,000 signatures. As a result of that, now all of a sudden there's plans that that they think may have some impact. The fact of the matter is, folks, the discussion is still not thinking outside of the box from the other side. When they said follow the rules in the prison, if you ever spend any time in a prison, you will know that it's extremely difficult to follow the rules because individuals are going to challenge you. They're going to fight. Things are going to happen. And then you're going to get dinged, and you're not going to be able to get the credits and things of that nature. And then this whole issue of the felonies. We have a draconian system when it comes to felonies. One felony can ruin your life. And then even if you get it expunged, it's extremely difficult if you live in certain areas of this state to stay out of trouble. And you may get another felony. My point is that we got to think outside of the box and stop thinking inside of the box.
If I could just, to the Klein-O'Brien plan, it's not just Issue 1 light, it's Issue 1 super light. There's very little impact that's going to come out of that. It waters down the ideas that are in Issue 1 with lots of exceptions, which is exactly what this legislature does every single time. If you look at the state prison population, we've been at 50,000 since 2007. And in between time, we've had things like this great gigantic Justice Reinvestment Initiative, which produced no impact to the prison population. We've had things like the Criminal Justice Recodification Committee, no impact to the prison population. We have TCAP that just started in the first year that has reduced the prison population maybe by a couple hundred. We are sitting on a 131% capacity prison population. 50,000 people is too many, and going down 0.5% per year is not going to do it. There are too many people in that state prison, and billions of $1.8 billion we waste every year in that prison system. We need to get that money out, and we need to get a significant number of people out safely, and that's exactly what Issue 1 does, and it takes it out. The most significant thing, I think, about the Klein-O'Brien plan is not the substance of it, watered down though it may be, but was the even more tepid reception that Senate President Obhoff gave it in the quote I read in the paper. Yeah, we'll think about it. Maybe next session we'll have to look at it. I'm not sure it would really pass.
Okay,
that's exactly what's going to happen.
Okay, that brings me to the idea here. Is there a chance that something would pass like this in the legislature? Have you been given any indication that if Issue 1 fails, that something else would be coming along that would take care of some of these things that are happening?
Well, if this is the plan or there's some other plan, yeah, I think it's premature to talk about whether this is going to be a plan that is going to be a viable alternative, and I don't think that's the point. I think we have to focus on Issue 1. One of my biggest problems with Issue 1 is the representation that 700,000 people signed this. Well, keep in mind that half of them were invalid. Which would suggest to me that they weren't registered to vote, and therefore, or citizens, or whatever the impediment was, they were invalid signatures. What was said to the people when they signed this petition? Are you for safe neighborhoods? if you are, sign this petition. Who wouldn't sign the petition? Nowhere was it disclosed that judges would not have the ability to incarcerate as part of a drug court program that would help someone on their road to recovery from their addiction. And that's extremely important. I think another really important feature of Issue 1 is that the collection of these signatures on the petition was completely funded to the tune of almost $5 million by entities who don't even live in the state of Ohio. I take particular exception to Mark Zuckerberg or George Soros or someone else who will not have to suffer the consequences that will be visited on the state of Ohio and our citizens if Issue 1 passes.
Okay, that will
There will
have
be
to-
people who will die.
Okay, that will have to be the end of that, but it's the CMC's tradition to take audience questions here, and questions today have been submitted in writing and selected by volunteer members of the Columbus Metropolitan Club's Program Committee to provide balance and cohesiveness. So let's get started with the first question, please.
I'm asking this question on behalf of Charlita B. Tavares. We know that there are many individuals who have been incarcerated unnecessarily, disproportionately African Americans and people of color. The Supreme Court and Ohio State Bar Association commissioned the Commission on Racial Fairness report issued in 2000 that indicated racism and discrimination existed from decisions to arrest, charges up through sentencing. Why wouldn't we want to reduce the prison population with those who have a disease and need treatment?
Why would you not? Yes.
Yeah, wow.
Why wouldn't we?
I think we would. Thank you, Senator Tavares. We certainly would want to reduce the prison population that way. We certainly want to tackle racial disparities. I think it's really telling that one of the key recommendations out of that racial fairness report is that the judicial system would collect and report data on race disparity in sentencing, in judicial outcomes, in prosecutorial decision-making and charging decisions. That was in 1999. Do you know that we sent a satellite to Saturn, Cassini, and successfully brought photos back from that, and still the judicial system is not reporting racial data. That's what we're saying is the system as it is now is intractable. It is resistant to reform that is needed in this state. Issue 1 will both increase safety and, I think, reduce racial disparity. From the data I've seen coming out of California, for example, with Prop 47, they've reduced racial disparity with the impact of their reforms there that were done through a ballot initiative.
And let me add,
Please.
and let me add to that the caveat and relative to racial disparities. Add to that the fact that Ohio is beginning more discussions toward privatization of its prison system. We have 3 private prisons currently in the state of Ohio, and they will be very vastly impacted by Issue 1. And add to that the fact that there are individuals that have received campaign contributions relative to the private prison system. So we have to understand that this is far beyond just an issue of, well, this is not going to be the best way to go. Issue 1 is going to transition an awful lot of situations in the state of Ohio relative to criminal justice.
Okay,
If I may. You know, I don't think anyone disagrees with the fact that we need to figure out ways to reduce the prison population. I don't think Issue 1 accomplishes that. And I've mentioned this once before, and again, I don't know if the chief likes to hear me say this, but I think the problem that we have with our prison population is the fact that over the years we have criminalized more behavior. Because of the fact that we've criminalized more behavior, the more things that people do that in terms of committing crimes, there's more crimes on the books, more people get charged with crimes, more people get convicted of crimes, and then unfortunately more people get sent to prison. So we do need to take a comprehensive look of the statutes that we currently have on the book to decide if there are some things that are currently criminalized that maybe we need to change. Issue 1 doesn't deal with that at all. And again, their remarks that even allowing for some level of good time is not going to have a significant impact on the prison population as well. To say that vote for issue 1 and the prison population immediately is going to go down. I don't see that happening, because the issues that have created the overpopulation within our prison system is not within the constitutional amendment. There's deeper, more complicated issues that have to be resolved. The racism that exists, absolutely. There are folks in prison that don't need to be in prison, shouldn't be in prison, and those are issues that we have to absolutely continue to try to tackle. But I don't think anyone disagrees that there needs to be ways to get more people out of our prison system.
I think one of the most important features for the success of issue 1, and you'll hear it from the proponents, is the amount of money that is alleged to be able to be saved by and redirected. I would suggest that you take a long, hard look at the Office of Budget and Management's report that just came out this week that said those numbers are not possible to be materialized, that they are premised on wrong information, that the numbers, the savings will not take place. And if there is anything to be appreciated from issue 1 is, if it's passed, the dollars won't be there. The inmates, many will be released from the institution. Many will not go to the institution because they will be transmuted to misdemeanors, and those individuals will be monitored on probation and in the municipal courts in the cities.
Okay, I'll
They
have
don't
to-
have the capacity to do that. There is no money to help with that burden.
Okay, we'll have to end that there. The next question, please.
Question on behalf of Ed Sweeney. If drug courts are so successful, why did only 14 graduate from Franklin County Drug Court last year? 540 died from overdose in Franklin County last year.
Okay. The drug court that we have here in Franklin County, we accept 50 persons. We have the capacity to handle 50 persons. The vast majority of the individuals that we have in our drug court are persons that have multiple prison numbers, as well as have been in the system. Many of them have reached a point where they said enough. And as I indicated before, I can't make them go through drug court. This is something that they have to volunteer to do. If 50 people started in my drug court today, in 18 months, maybe 10 of them would graduate because of the fact that relapse is a part of recovery. So of those 50 persons that started in my drug court today, many would relapse. Some would quit the program. Some would abscond, which means that they would leave and a warrant would be out for their arrest. But of those 10 that graduate from that 50 that started, our statistics show that 80% of them don't make it back into the system. Okay? And of those 50 that started, many of them will finish, but they'll finish after 2 years, after 3 years, after 4 years. And we've had persons in the program for 5 years that we've continued to work with. Relapse, progress, relapse, and we continue to work with them. So no, drug courts work because of the fact that those who finish drug courts don't tend to go back into the system.
Mr. Johnson Grove or Senator Thomas, would you like to quickly rebut that?
We have no qualm with drug courts. Again, like, drug courts will continue to be able to operate. They can hold people accountable. There will be funding for them. That's not where the issue is. The thing I do want to get clear, though, about is the resources that will be made possible under Issue 1. If you are going to read the faulty, politically motivated Ohio Budget Management Report, please also read the one published by Jim Austin, as well as the one by Policy Matters Ohio, both of which project north of $100 million per year saved under Issue 1. Incidentally, because I've looked deeply at all three reports, they all started from the same data. They're all based on DRC, original prison system data. The question is the assumptions they make. What OBM presumes is that every single judge and every single prosecutor will resist Issue 1 to the hilt. That may happen in some places. It certainly happened with Justice Reinvestment Initiative, which is why we got such dampened results with that initiative. But issue 1 is written much stronger than the Justice Reinvestment Initiative, and I'm confident that's why it will have much better impact than any of those failed pieces of legislation from the past.
Okay, our next question.
The next question is from Kathy Fox. The question is, would each of the panelists support a change in the Ohio Constitution to allow initiatives that would change statutes, including the restricted statute option mentioned earlier? And if you could respond, why or why not?
Yes. Absolutely, absolutely. In fact, that was one in the string of skunked and failed things that our legislature has done. Put on that same graveyard the Ohio Constitutional Modernization Commission, which was supposed to do exactly that. And that was something that my office and others were very excited to see. I think it would have been a great idea. That's what some of those other states that the Chief Justice listed that have reduced felony drug possession down to misdemeanor have done so using a mechanism just like that.
Yeah, the whole purpose of the recodification committee, and our judge here spoke a little bit about he said the statutes on the books, where we looked at all of the drug statutes in the recod committee, and we came up with recommendations, including addressing the 4th and 5th degree felony issue. And again, the legislature has chosen not to address these particular recommendations. 18 states, the legislators have they have passed very similar laws relative to issue 1. In other words, folks, I keep going back. It takes a political will to get this done, and it has not been the political will of the state of Ohio to get it done.
Okay, quickly, Senator, I want the other side to jump in here and give a quick rebuttal, and then we're going to go to closing statements.
One of the major differences, and I said this at the beginning, is that any state that has changed their policy on offenses from felonies, low-level felonies, to misdemeanors have retained the judge's ability to incarcerate if there is the need to incarcerate. And that's the big difference here, is that, I've said it once, I'll say it again, you can have 19 grams of fentanyl, enough to kill 10,000 people. It's a misdemeanor, and no judge can put you in jail for that. And you can do it again within 24 months, and the same result. You cannot be put in jail for that.
Okay.
And I think that's a serious flaw.
We're going to have to leave it there. So now we're going to go to the closing remarks. We'll finish with 30 seconds for each side. The anti-side will go first, followed by the for side. So Justice and Judge, it's yours.
Look, I'm going to try to quickly summarize an email that I received from a father whose son was in my drug court. And his email says that I don't believe my son will turn himself in. There was a warrant out for his arrest. No matter how much we tried to convince him, I'm so sorry for the disrespect for you in the courts. I will be forwarding his license plate number, and I will call the Fairfield County Police or State Patrol if he does not come home to Columbus so that we can get him under wraps. He was trying to get his son arrested and off the street. He eventually said, after his son was picked up, that I don't want to give up on my son, because something has to change. And he says, I stated to you that in Ty's court, the drug court, I do not believe that he can make it without the Vivitrol shot. He has to get the monkey off his back.
Okay, and that will have to be it for you. For the other side, you have 30 seconds to make your closing remarks.
Thank you. Issue 1 will make sure there are more Vivitrol shots for that son. Issue 1 will make sure there's more resources inside the justice system, as well as, most importantly, outside the justice system for the drug treatment that people need in this state. If it's not already open, I know very soon the 1851 Constitution is going to be put on display downtown at the State House. And my favorite part is the big bronze thing around the top, the first sentence of the Ohio State Constitution. All political power is inherent in the people. The legislature has failed to deal with this issue in a meaningful way. Now is your chance to vote yes on issue 1 and get this done.
Thank you.
I hope you found today's forum very informative. Now that we have an overview of state issue number 1, I encourage you to read the legislation so you better understand what it says and can make an informed decision in a couple of weeks. And yes, this is a reminder, it is your responsibility to vote. So make sure it's on your calendar if you haven't done early voting. Let's thank the Ohio Farm Bureau Federation and Hannah News Service for their support. And of course, our speakers, Stephen Johnson Grove, Cecil Thomas, Stephen McIntosh, and Maureen O'Connor, and of course, Joe Engels. Thank you. See you this Friday and next Wednesday. Thank you.